ABAWD engagement policy, including information on the 36-month fixed time clock, waivers, and how ABAWDs are tracked. Next, we'll give you an overview of the CalFresh work registration requirements and the ABAWD time limit policies. We will then touch on some key policy topics, including identifying your ABAWD population, screening for ABAWD exemptions, how ABAWDs can satisfy the work and community engagement requirement to continue receiving benefits, ongoing ABAWD eligibility, and discretionary exemptions. After that, we'll go over the implementation changes under HR 1. Lastly, we will end with a Q&A session. As a reminder, please submit your questions in the Q&A box at any time during the presentation. Let's get started with some background. The ABAWD time limit was introduced as a result of the federal welfare reform through the Personal Responsibility and Work Opportunity Reconciliation Act of 1996. Under this provision, able-bodied adults without dependents, or ABAWDs, were time limited to receiving 3 months of SNAP or CalFresh benefits in any 36-month period. States are required to track and measure the 36-month period in which an ABAWD receives benefits. There are several options states can choose from, and California has chosen what is known as a fixed statewide clock. This means that all ABAWDs in California are tracked in the same 36-month period. Under this option, there is a definite start and stop date for every ABAWD statewide. The current 36-month period began on January 1st, 2026, and continues uninterrupted regardless of whether the ABAWD is meeting the work and community engagement requirement, is exempt, or is living in a waived area. The current 36-month period will end on December 31st, 2028, and a new clock will start on January 1st, 2029. With the passage of House of Representatives 1, also known as HR 1, ABAWD time limit waivers are now granted based on areas of unemployment rates above 10%, and waiver criteria based on a lack of sufficient jobs was eliminated. CDSS applies for ABAWD time limit waivers on behalf of all counties that qualify, but final approval lies with the United States Department of Agriculture's, also known as USDA, Secretary, who may deny a request even if the eligibility condition is met. As outlined in All County Letter number 2541, the USDA Food and Nutrition Service has ended approval of 2-year waivers and now limits all waivers to 1 year to allow for more frequent reassessment of labor market conditions. California's statewide ABAWD time limit waiver ended on January 31st, 2026. However, counties cannot implement the ABAWD time limit until June 1st, 2026 for new non-exempt applicants. For ongoing households, the ABAWD time limit will be applied to non-exempt household members at their upcoming recertification, due on or after June 1st, 2026. We will discuss this later on in the presentation. As announced in All County Letter number 2579, Colusa, Imperial, and Tulare counties have been approved for a 1-year waiver effective from November 1st, 2025 through October 31st, 2026. Additionally, as announced in All County Letter number 2615, FNS has approved additional waivers for Alpine, Merced, Monterey, and Plumas counties, also effective from November 1st, 2025 through October 31st, 2026. Next, we will discuss work registration and the ABAWD time limit policies, and how, while they are independent, they relate to one another in some areas. I want to start with an image to put the populations we will be discussing into perspective. We're going to start with our largest pool of all CalFresh recipients. From there, we have a subset of CalFresh recipients who are considered work registrants. Federal SNAP regulations require all CalFresh recipients to be registered for work unless they qualify for an exemption from work registration. There are no waivers for work registration. Going further down, we have a subset of CalFresh work registrants who are considered ABAWDs. And even further, we have those ABAWDs who are considered subject to the time limit or non-exempt. Let's dive into work registration. Definitions of a work registrant and an ABAWD are slightly different, and they have different requirements. Work registrants are individuals who are between the ages of 16 to 59, working under 30 hours per week, and do not qualify for a work registration exemption. What this requires is that the individual be registered for work, meaning that they have their work registration status notated in their case record and in the eligibility system. Additionally, the work registrant must accept suitable employment if offered and not voluntarily quit or reduce their work hours to less than 30 per week. By contrast, ABAWD time limit rules are a little different. To be considered an ABAWD, the individual must be between the ages of 18 to 64 and not qualify for an exemption from the ABAWD time limit. ABAWD time limit exemptions and work registration exemptions are different, but overlap in some areas. We'll go over both in detail later in the presentation. ABAWD time limit rules, when in effect, require the individual to work or participate in a qualifying work activity for 20 hours per week, average monthly, for a total of 80 hours per month, in order to receive CalFresh benefits beyond the 3-month time limit. For each month in the 36-month period, it is required that the county track each ABAWD's participation status, including if they are exempt, if they've used any of the 3 countable months, if they've used their 3 consecutive months, if they've satisfied the work and community engagement requirement, or if they've received a discretionary exemption, all of which we will discuss later in the presentation. Tracking only begins for ABAWDs who are subject to the time limit and continues for the remainder of the 36-month period. ABAWD participation and status is tracked in the California Statewide Automated Welfare System, also known as CalSAWS. Monthly status for ABAWDs are tracked using various statuses, which include if the ABAWD has either met the work and community engagement requirement, did not meet the work and community engagement requirement, used a countable month, used a consecutive month, was granted a discretionary exemption, or received a prorated month. Non-assistants, CalFresh, work registrants, able-bodied adults without dependents, an employment and training program quarterly statistical report, also known as the Stat 47, is a required report for tracking ABAWDs, work registrants, and ENT participation, regardless of waiver status. When a waiver isn't in place, counties must also track any allocated discretionary exemptions. And that wraps up tracking responsibilities. I will now pass it over to Juliana to go over the 3-step process.
Hello, my name is Juliana Chiama. I'm a policy analyst with the ABAWD policy team, and I'll be going over the 3-step process. CDSS has identified this 3-step process as a best practice in implementing the ABAWD time limit, with the first step being to identify who your target ABAWD population is. An essential part of implementing the time limit is understanding who your target population is. So similar to our bubbles image earlier, we start with a CalFresh recipient. On the left side of the chart, the recipient meets the criteria for work registration exemption and is therefore not a work registrant and not an ABAWD. This applies to all work registration exemptions other than age. We will cover this more in details in the upcoming slides. On the right side of the chart, we have CalFresh recipients who don't meet the criteria for work registration exemption and are considered work registrants. Work registrants who are 18 to 64 years old are further screened for exemptions from the ABAWD time limit, and those who do not meet the criteria are considered subject to the time limit. Now let's go through step 2, which is to screen for exemptions. How do we determine if someone meets the criteria for an ABAWD exemption? The answer is effective screening. Because such a significant portion of the ABAWD population may be exempt from the time limit, effective screening and client communication is crucial. Counties may or may not have enough information in the existing case record to determine whether a client is exempt from the time limit. A combination of both effectively using the information that is already available in the case record and individualized assessments by eligibility staff will be required in order to fully assess if an individual meets the criteria for an ABAWD exemption. We know that many ABAWDs face significant barriers to employment, and we know from other states that exemption screening is absolutely critical. This is because roughly half to 2/3 of your ABAWD population is likely exempt. The question we need to ask is, does this individual's circumstances hinder their ability to participate in work or work activities for 20 hours per week or 80 hours per month? The ABAWD time limit exemption categories are intended to identify individuals who are not able to satisfy the work and community engagement requirement for a variety of reasons. Good exemption screening means less ABAWDs subject to the time limit, which is less benefits lost and will reduce county workload. we're going to walk through the different exemption categories, explore the criteria for each, and provide a quick overview of what verification is necessary for each. ABAWDs meeting any of these criteria are exempt and therefore not subject to the time limit. ABAWD exemptions include exempt from work registration for any reason other than their age, ages under 18 or over 64, medically certified as physically or mentally unfit for work, a parent or responsible for a dependent child under the age of 14, pregnancy, participating in an Office of Refugee Resettlement, also known as ORR training program, and those who are Indian, Urban Indian, or California Indian as defined under the Indian Health Care Improvement Act. The first exemption we will cover is if the individual is exempt from work registration. Because ABAWDs are a subset of work registrants, counties must apply work registration exemptions first. Keep in mind, work registration exemptions are only assessed at application and recertification. Work registration exemptions include individuals who are 1. Under age 16 or over 59. Note here that if an individual ages 60 to 64 is exempt from work registration solely due to their age, they must meet another work registration exemption or any other ABAWD time limit exemption in order to be exempt from the ABAWD time limit. 2. Attending school or enrolled in an ENT program at least half-time. 3. Physically or mentally unfit for employment. It's important to note here that physical or mental unfitness under work registration must be tied to a disability. 4. Complying with requirements of welfare to work. 5. Caring for an incapacitated person or dependent child under age 6. Another important note here is that under work registration, the incapacitated person or the dependent child under the age of 6 do not have to be living in the home in order for the person to qualify for the exemption. This exemption is limited to 1 adult per child under age 6 or incapacitated person. Multiple adults may not claim the exemption for the same child or an incapacitated person. This is different under ABAWD time limit rules, which we will discuss in a few moments. 6. Receiving or have applied for unemployment. 7. A regular participant in a drug addiction or alcohol treatment and rehabilitation program. And finally, employment and self-employed for a minimum of 30 hours per week or receiving weekly earnings equal to the federal minimum wage times 30 exempts a person from work registration. Note that this total is currently $217.50 a week. If an individual earns at least $217.50 a week, they are exempt from both CalFresh work registration and the ABAWD time limit. The next exemption is age. Individuals are exempt from the ABAWD time limit if they're under the age of 18 or over the age of 64. H.R. 1 increased the upper age limit from 54 to 64. Individuals may be considered an ABAWD the month after their 18th birthday. Individuals are no longer considered an ABAWD the first day of the month after their 65th birthday. The third exemption is medically certified as physically or mentally unfit for employment. There are three subcategories which make someone medically certified as physically or mentally unfit for work. The first is receiving public or private disability benefits. The second is if the person is obviously unfit. And the third is medical verification. We will go through each of these in detail. The first being individuals who have applied for or are receiving temporary or permanent public or private disability benefits are exempt from the ABAWD time limit. Sources include, but are not limited to, SSP, SSI, SSDI, workers' compensation, temporary or permanent disability insurance or similar benefits, veterans' disability benefits, or disability-related general assistance or general relief. Verification for these exemptions may be proof of receipt or pending application, and this information may also already be known to the county. Next, individuals who are obviously unfit for work are exempt from the ABAWD time limit. This determination is made by the eligibility worker during the intake or recertification interview, either face-to-face or via telephone. Examples include observing that a person has an injury, noting that a client is having trouble following the interview or is asking incoherent questions, severe dental issues, personal hygiene issues, etc. Case notes mentioning that the individual is unfit for work due to medical reasons suffice as verification. We recognize that this determination may cause some unease, but we want to emphasize that this determination is solely for the purpose of exempting an individual from the ABAWD time limit. Eligibility workers should feel empowered to make the determination. Federal rules do allow counties this flexibility to prevent placing unnecessary burden on individuals who are clearly unfit for employment. Now we're going to talk about a few indicators of obvious unfitness. Therefore, we're going to go over experiencing chronic homelessness, drug and alcohol abuse, survivors of domestic abuse, and individuals impacted by the child welfare and juvenile justice systems. Additionally, individuals are not limited to experiencing only these four indicators to qualify for an exemption due to mental or physical unfitness for employment. To be exempt, the individual's unfitness to work must be associated with a physical or mental illness or condition that reduces or affects their ability to regularly work 80 hours per month. Other circumstances, such as trauma or prior experiences linked to current physical or mental health conditions, may also render an individual unfit for employment and therefore eligible for this exemption, such as trauma associated with child welfare or juvenile court system involvement, prior or ongoing juvenile court system involvement, military service trauma, etc. Starting with experiencing chronic homelessness. The CalFresh definition of homelessness is lacking a fixed or regular nighttime residence. Individuals are considered chronically homeless if they meet the current CalFresh definition of homelessness and if they have been homeless 6 months or more, have been homeless more than one time in the last year, or state that they're unable to meet their basic needs. Basic needs include, but are not limited to, adequate shelter, heating and cooling, electricity, running water, food, and clothing. It's not the homelessness that makes a person exempt, but rather a condition associated with homelessness. The key is that the issue must be tied to a physical or a mental unfitness to be considered as physically or mentally unfit for employment. Next are individuals experiencing drug or alcohol addiction. This indicator is different from the exemption from work registration, in that the individual does not have to be participating in a treatment program to be considered obviously unfit for work, but the addiction must be tied to a physical or mental unfitness. Next are survivors of domestic abuse. This is defined as an individual who is a survivor or has experience of exposure of any type of assaultive, coercive, or battering behavior occurring within a domestic relationship. This policy is not restricted to just an intimate partner. It applies to other relationships such as sibling, parent, friends, and others. This is also not limited to those that are in the domestic violence shelter. Again, just like chronic homelessness, drug and alcohol addiction, the domestic abuse issue must be tied to a physical or mental unfitness. Next are individuals impacted by the child welfare and juvenile justice systems. This is defined as young adults with experience in child welfare or juvenile justice systems. Individuals are considered to be involved in child welfare if they meet one or more of the following criteria. The individual has ever had an open child welfare services case, or the individual was determined by a child welfare services agency to be at imminent risk of entering foster care, but was able to safely remain in their home, or kinship placement with the provision of services under a prevention plan, or the individual is a young adult whose adoption or guardianship occurred through the child welfare system. Individuals are considered to be impacted by juvenile justice systems if they meet one or more of the following criteria. The individual has ever been detained or committed to a juvenile justice facility, or the individual is currently under supervision by the juvenile delinquency court and or a juvenile probation agency. Again, just like chronic homelessness, drug and alcohol addiction, and survivors of domestic abuse, this issue must be tied to a physical or mental unfitness. I want to pause here to emphasize that these are only indicators that a person may be obviously unfit to work, and they're not exemptions in and of themselves. County observation is the only required verification when the reason for the unfitness is obvious. No further information is necessary, and additional verification is not required. For survivors of domestic abuse, the individual's statement that they are a current or past survivor must be accepted. Now, if the unfitness is not obvious, the county must secure medical verification of the unfitness. This is for issues that cannot be determined during the interview. For this one, medical verification is required. The optional CalFresh request for medical or mental health verification form, CF 887, may be used to verify a medical exemption. Another alternative is a written or verbal statement from a medical or mental health professional such as physician, nurse practitioner, dentist, and social worker. Just to be clear, verification is not needed for individuals who are already included in the case file for another program, assuming that the case file is accessible to the eligibility worker. The next exemption is a parent or responsible for a dependent child under the age of 14. For the purpose of the ABAWD exemption, a household means a CalFresh household. The child can be an ineligible member of the CalFresh household for any reason. The child can also be temporarily absent from the home for no longer than 30 days. A single dependent child under age 14 may exempt more than one adult in the same CalFresh household. The individual's responsibility is established by the CalFresh purchase and prepare rules. For verification, inclusion of a child under 14 in the same CalFresh household found in the application or recertification documents or verbal statement from the client is sufficient unless questionable. A signed affidavit is not required. Prior to H.R. 1, individuals living with a household member under the age of 18 were exempt. The updated rule takes effect on June 1, 2026 for new applicants, and ongoing households will be subject to this change at their next recertification due on or after June 1, 2026. Being pregnant also exempts an ABAWD from the time limit. This is any stage of pregnancy effective beginning the month of conception. Client statement is sufficient verification for this exemption. Individuals who are participating in an Office of Refugee Resettlement ORR training program for at least half time are exempt from the ABAWD time limit. Verification of this exemption may include documentary evidence or a written statement from the ORR training program. An acceptable collateral contact may also act as verification. For our final ABAWD time limit exemption, individuals who are Indian, Urban Indian, or California Indian under the Indian Health Care Improvement Act are exempt. This is a new exemption established by H.R. 1. Like other H.R. 1 changes, this exemption will be available beginning June 1, 2026 for new applicants, and ongoing households may qualify for this new exemption at their recertification due on or after June 1, 2026. Client statement is sufficient verification for this exemption. Additional verification is only required if the county deems the information received to be questionable. The county must exhaust all internal information before requesting verification from the individual. A few final thoughts on ABAWD exemptions. We want to stress one more time that indicators are not exemptions. Counties must not list an indicator of an obvious unfitness as the reason for the exemption, or it will be considered an error. Verification is flexible and adequate case narrative is required. Remember, there is always the option to verify questionable information. A quick note about how long exemptions may be granted. ABAWD exemptions are typically granted for the length of the certification period, unless the county has an expected end date for the exemption. If there's an anticipated end date, the county is required to follow up with the client and rescreen at the time. And finally, the county is able to make changes to the case retroactively in the 36-month calendar. For example, if a county finds out that a person was considered subject to the time limit but was actually exempt, the county may go back and update the calendar to reflect those changes. Our third and final step is engaging in work. ABAWDs that are not eligible for any of the exemptions we just discussed are subject to the time limit and must satisfy the work and community engagement requirement to continue receiving benefits beyond the 3 countable months. Going back to this image of the different populations, we're now operating in the innermost circle, where ABAWDs are subject to the time limit and must satisfy the work and community engagement requirement. ABAWDs can satisfy the work and community engagement requirement in a variety of ways. This can include employment, qualifying employment, and training activities, WIOA programs, programs under Section 236 of the Trade Act of 1974, community service or volunteer work, and workfare. To satisfy the work and community engagement requirement, an ABAWD must work 20 hours per week, averaged monthly for a total of 80 hours per month, and most activities can be combined to reach the hourly requirement. As a note, the hourly requirement for workfare is calculated differently, and other activities cannot be combined with workfare. We'll go over that in more details later. Satisfying the work and community engagement requirement through employment includes paid employment, self-employment, and in-kind work. In-kind work is work in exchange for goods or services. For example, doing maintenance work in exchange for reduced rent. Required hours are 20 hours a week or 80 hours a month and is combinable with other qualifying activities. ABAWDs can also satisfy the work and community engagement requirement through CalFresh Employment and Training, ENT. Employment and training components that satisfy the work and community engagement requirement are called qualifying activities. Qualifying work activities consist of workfare, work experience, vocational and self-employment training, educational activities, and job retention. As with employment, most of these activities can be combined to meet the 80 hours monthly average. Next is WIOA, or the Workfare Innovation and Opportunity Act programs. Can also be used to satisfy the work and community engagement requirement. It helps people get the skills they need to find good jobs and start careers. It also helps connect employers with workers who have the right skills to succeed in today's economy. WIOA programs include job search, resume workshops, job fairs, and referrals and training at no cost. Again, this is a 20 hours per week or 80 hours total per month requirement and is combinable with other activities. Programs under the Section 236 of the Trade Act of 1974 can also help ABAWDs to satisfy the work and community engagement requirement. This program specifically provides training services to workers affected adversely by trade agreements. These are programs such as Supervised Job Club, On-the-Job Training, WIOA Training, or remedial educational programs. They are also combinable with other work activities I've mentioned to meet the 20-hour a week or 80 hours a month requirement. An ABAWD may also do community service or volunteer work to meet the required hours. For this option, an authorized representative of the organization must verify the hours worked by the ABAWD. Counties may use the optional CF 888 to obtain this information. Participants may complete community service at a non-profit or public institution of their choice, including religious or community organizations, as long as the county can verify their hours. The required hours for community service work is 20 hours per week or 80 hours per month, and is combinable with all other activities mentioned previously. Next, we're going to discuss Workfare. Workfare is a program that essentially allows ABAWDs to work without pay in exchange for receiving CalFresh benefits. The key difference with Workfare is that the required number of hours to satisfy the work and community engagement requirement are calculated differently. The required monthly hours are calculated by dividing the entire CalFresh household allotment by the state or local minimum wage, whichever is higher. Additionally, Workfare is not combinable with any other work activities I've mentioned. It must be completed on its own as a way of satisfying the work and community engagement requirement. Here's an example of how the hourly requirement for Workfare is calculated. Sarah's CalFresh allotment is $205 per month, and California's current minimum wage is $16.90 per hour. Dividing $205 by $16.90 gives 12.13, which is rounded down to 12 hours. Therefore, Sarah would need to participate in Workfare for 12 hours per month to meet the ABAWD work and community engagement requirement. Now we will cover other qualifying activities that may also count towards the ABAWD work and community engagement requirement. Certain activities completed by youth in or leaving foster care may count toward the ABAWD work and community engagement requirement. Participation in extended foster care, EFC, may be treated as meeting the ABAWD requirements when the activities align with allowed work activities under Title 7 CFR 273.24a. EFC eligibility, which is for foster care between ages 18 to 21, requires at least one of the following: attending school, high school or post-secondary, working at least 80 hours per month, engaged in a program that reduces barriers to employment, or having a qualifying medical condition. ILP and CILP activities. Older foster youth may participate in independent living services and transitional independent living plan activities that prepare them for adulthood and employment. When aligned with federal definitions of allowable work or education or training, these hours may count toward ABAWD requirements. Examples of qualifying activities are extended foster care under WIC 11403B4, WIOA Youth or America's Job Center of California, AJCC programs, California Opportunity Youth Apprenticeship, COYA, volunteer and leadership programs such as CA Youth Connection or Youth Engagement Project, continuous quality improvement, CQI, activities and listening sessions, Job Corps, volunteers in service to America, VISTA, Ticket to Work, Foster Jobs Program. I'll pass it over to Tanya to go over ongoing ABAWD eligibility rules.
Hello, everyone. My name is Tanya Kaur. I am a policy analyst with the ABAWD policy team. And next, we will talk about some ongoing ABAWD eligibility rules. We've talked about countable months a few times throughout this presentation. And now, we will talk about identifying a countable month. A countable month is any month in which an ABAWD receives a full month of CalFresh benefits while not being exempt, not satisfying the work and community engagement requirement, not living in a waived area, not qualifying for good cause, or not receiving a discretionary exemption. Please note that ABAWDs are only allowed 3 countable months of benefits during the 36-month period. By contrast, non-countable months are months that do not count towards the 3-month time limit. These are months in which the ABAWD satisfies the work and community engagement requirement, receives a partial or prorated month of benefits, qualifies for an exemption, receives a discretionary exemption, or has good cause. Next, good cause may be determined for ABAWDs who fail to meet the work and community engagement requirement for reasons outside of their control. This includes, but is not limited to, illness, household emergency, lack of transportation, or disaster. This also includes individuals who received hardship for Medi-Cal as well. With the passage of Assembly Bill 2300, effective January 1st, 2023, CalFresh recipients are entitled to a broader scope of protection from sanction for non-compliance with work registration. Even if a work registrant resigns from their position, they still may have good cause if they attest that their civil rights were denied or violated under any state, federal, or local law protecting equal employment opportunity. No documentation is necessary to corroborate this unless otherwise required. AB 2300 also extends good cause to individuals who provide proof of unforeseeable work hours that interfere with their ability to reliably meet the work and community engagement requirement. Additionally, individuals who have received a hardship determination through Medi-Cal may also be considered to have good cause. The key concept here is that the individual would have satisfied the work and community engagement requirement had their situation or circumstance not happened. There is no limit on the number of months a person can receive good cause, but it is a monthly determination. Let's look at a few examples to see what a non-countable month might look like. Example 1. An ABAWD individual applies for benefits on the 15th and receives a prorated benefit allotment. This is considered a non-countable month because it's a partial month of benefits. Now for example 2. An ABAWD individual is sick with the flu for part of the month, causing them to miss some work and not satisfy the work and community engagement requirement for that month. This is considered a non-countable month due to good cause. Here, I want to give you a couple more examples of an ABAWD's 36-month calendar to emphasize how calendars can vary. In this example, the ABAWD was living in a waived area for all of year 1 until August of year 2. In September, their county implemented the ABAWD time limit, and this person did not meet the work and community engagement requirement or meet an exemption while still receiving CalFresh benefits. So they received a countable month in September, October, and November as shown in year 2. In December of that year, they were discontinued. Next, we see in February of year 3, they regained eligibility for CalFresh. We will talk about ways a client can regain eligibility in a few moments. From March to July of year 3, we see the person is working, and then in August through September, we see they receive the 3 consecutive months. We will talk about the 3 consecutive months and how it differs from the countable months shortly. After receiving their 3 consecutive months, they again met the work and community engagement requirement in November and December of year 3. Here's another example of an ABAWD's 36-month calendar. In this example, the ABAWD has used a countable month in the very first month of the 36-month calendar. Afterwards, they satisfied the work and community engagement requirement until September of year 1, where they were discontinued. As a note, this person was discontinued for reasons other than the ABAWD time limit, as they only used 1 of their 3 countable months up to this point. Sometime between September and December of year 1, they regain eligibility by working 80 hours in a 30-day period. In January of year 2, they regain eligibility, reapply, and receive a partial month of benefits. Afterwards, they work again until May, where they receive another countable month, their 2nd. In June, they meet the work and community engagement requirement again until October, when they use their 3rd and last countable month. Afterwards, they satisfy the work and community engagement requirement until July of year 3, where they receive the 3 consecutive months of benefits before finally being discontinued in October of year 3. Inter-county transfers always result in the receiving county's new responsibility, but there are procedural differences between ABAWDs who move to a waived area versus a non-waived area. When an ABAWD moves to another county within California, it's important to know that some counties may still have an ABAWD time limit waiver in place. Moving does not restart the 36-month period or the 3-month time limit. The record remains with the client until a new 36-month period begins. Counting months is based on the waiver eligibility of where the client resides. When an ABAWD moves to a non-waived county, the sending county is responsible for determining the ABAWD status at the ABAWD's certification or next recertification. The receiving county is now responsible for tracking the ABAWD individual and ensuring they're meeting the work requirement if applicable to them. If an ABAWD moves to a waived area, they are no longer subject to the time limit and are not required to satisfy the work and community engagement requirement. They should, however, still be screened for exemptions, which must be noted in the case record. ABAWDs who are not exempt are subject to the time limit rules once they move to a non-waived area. This means they must satisfy the work and community engagement requirement, qualify for an exemption, or receive a discretionary exemption to receive CalFresh benefits beyond 3 months. Benefits received while not being exempt or satisfying the work and community engagement requirement will count toward the 3-month time limit. ABAWDs subject to the time limit are required to report when their work hours drop below 20 hours per week or 80 hours per month within 10 days. Counties are required to take action on any mandatory reports which may result in a reevaluation of exemption status, good cause determination, use of the discretionary exemption, application of a countable month, application of 3 consecutive months, or discontinuance. An ABAWD that has used 3 countable months will be discontinued and will be ineligible for CalFresh the month after the last countable month is used. For single ABAWD households, the case will be discontinued. For ABAWDs in households with other members, they will be excluded from CalFresh benefits. To receive CalFresh benefits again, the ABAWD must become exempt, regain eligibility by meeting the work and community engagement requirement over a 30-day period, or move to a waived county. After an ABAWD has been discontinued, they may regain eligibility for CalFresh benefits a few different ways. An ABAWD may regain eligibility by satisfying the work and community engagement requirement over a period of 30 consecutive days. This can be any 30 consecutive day period and does not have to be a calendar month. They can also regain eligibility by qualifying for an exemption, moving to a waived area, or reaching the end of the 36-month period. There is no limit to the amount of time ABAWDs are allowed to regain eligibility as long as they qualify. ABAWDs must submit a new application each time with proof of hours worked if they've regained through employment. They will also receive a new certification period, and the 3 countable months will not start over. Next, I'll talk about the 3 consecutive months, which we've mentioned a few times throughout the presentation. ABAWDs may be granted an additional 3 consecutive months of CalFresh eligibility beyond the 3 countable months. These consecutive months are only available in certain circumstances. To receive the 3 consecutive months, the ABAWD must have been discontinued for failure to satisfy the work and community engagement requirement and then regained eligibility by satisfying the work and community engagement requirement in a 30-day period and then subsequently stopped working again. I'll say that again. To receive the 3 consecutive months, the ABAWD must have used their 3 countable months and been discontinued, then regained eligibility by working 80 hours in a 30-day period, and then stopped working again. At that point, they would be granted the 3 consecutive months of CalFresh. These 3 consecutive months are available once and must be used consecutively. Even if the ABAWD works or meets an exemption during the consecutive month period, they will continue to receive consecutive months until they've gotten 3 in a row. It is important to note that all CalFresh eligibility rules apply during this period. In other words, ABAWDs must meet all CalFresh eligibility requirements, including submitting a SAR 7 or recertification if it is due, or making any mandatory mid-period reports. Let's go through an example. The ABAWD receives a partial month in January of year 1. They then receive 3 countable months of benefits in February, March, and April. They are discontinued in May and regain eligibility by working some time in May, June, or July and reapply in August to receive a partial month of benefits. They satisfy the work and community engagement requirement from September of year 1 until February of year 2, where they are discontinued again. In year 2, they will receive their 3 consecutive months before being discontinued in June. Now, let's go over the discretionary exemptions. A little bit of background on the discretionary exemption. Discretionary exemptions are formerly known as 15% or percentage exemptions. On October 1st of 2023, the Fiscal Responsibility Act, FRA, of 2023 reduced the annual allocation from 12% to 8%. The FRA also will impact how discretionary exemptions are carried over from each federal fiscal year. Effective October 1st of 2025, counties are no longer able to carry over their accrued discretionary exemptions beyond the prior federal fiscal year. Because of this, there are no discretionary exemptions available after October 1st of 2025. Following the implementation of H.R. 1 in June of 2026, counties without waivers will begin to accrue discretionary exemptions. Discretionary exemptions are individual exemptions allocated to the state by FNS that are equal to 8% of a state's caseload of ABAWD subject to the time limit, or non-exempt. These are only allocated when the ABAWD time limit is in effect. The discretionary exemption allows selected ABAWDs to receive CalFresh benefits beyond the 3 countable months. These were developed in recognition that the ABAWD work and community engagement requirement is difficult to meet for some participants and is complicated to implement. Please note that one discretionary exemption is equal to 1 month of benefits for one ABAWD. Here is an illustration of how the discretionary exemptions are allocated. FNS allocates a certain number of discretionary exemptions to CDSS based on 8% of the California's caseload of ABAWDs who are subject to the time limit or not exempt. CDSS will then distribute that allocation to implementing counties. And the county, at their discretion, will allocate the exemption to the ABAWD. If more discretionary exemptions are used than what was allocated, the number of overused exemptions will be deducted from the allocation the following year. Please note that if the negative balance is not fully offset, FNS will hold the state liable for the remainder. Now, we are going to go over the discretionary exemption criteria guidelines. There is maximum flexibility in terms of allocation, but we have identified target areas for the use, which include overissuance and error protection, eligibility extension, and special circumstances. Starting with overissuance and error protection. Discretionary exemption can be granted to individuals who were inadvertently issued CalFresh benefits after exhausting their 3 countable months, who did not satisfy the work and community engagement requirement, or who did not qualify for an exemption. The county may assign a discretionary exemption rather than establish an overissuance claim. Next, CalFresh eligibility extension. Eligibility may be extended for those ABAWDs who make an effort to satisfy the work and community engagement requirement. For example, an ABAWD who worked 10 to 19 hours a week versus the required 20 hours. And finally, special circumstances. The county may provide a discretionary exemption to ABAWDs in the following special circumstances: re-entry, probation, or criminal record, seasonally employed, dependent child ages out, former foster youth, family reunification, close to qualifying for an exemption or no longer being considered an ABAWD, and exonerated persons. In terms of applying discretionary exemptions, there is an order of operations. First, does that ABAWD qualify for an exemption from the time limit? If yes, stop here. This client is exempt from the ABAWD time limit. Next, can good cause be determined? If yes, stop here. This client would have satisfied the work and community engagement requirement had it not been for their specific circumstance. If neither of these apply, a discretionary exemption may be granted. Whether to apply a good cause or a discretionary exemption to an ABAWD depends on the individual case at hand. For example, two non-exempt ABAWDs who live in non-waived areas and have both already exhausted their 3 countable months. ABAWD 1 explained that they could not afford the bus pass for the month to get to work. This represents good cause, so the ABAWD will be excused from the time limit for that month. ABAWD 2 explained that they were fired because they were no longer needed for the holiday season. The county should apply a discretionary exemption to the ABAWD for having a special circumstance. Now, I will pass it over to Caitlin to go over the notice requirements.
Thank you, Tanya. Now we will go over noticing requirements. Following are the notices and forms available for ABAWDs. First up, we have the CalFresh 377.11, which must be sent no later than 10 days prior to discontinuance. Then we have the CalFresh 377.11a, which must be sent no later than 10 days after the 3 consecutive months have been granted. Following that, we have the CalFresh 377.11b, which should be sent no later than the 5th day of every month during which the county, based on the most recent information available, assumes the ABAWD is not satisfying the work and community engagement requirement and subsequently receives a countable month of CalFresh benefits. Then we have the CalFresh 377.11d, which must be provided to the individual ABAWD subject to the time limit when the individual is granted a discretionary exemption. If a household includes more than one individual ABAWD subject to the time limit, separate notices should be sent to each impacted ABAWD. Then we have the CalFresh 377.11e, which may be completed by county eligibility staff or an ABAWD to self-report that they may meet any of the exemption criteria. Finally, we have the CalFresh 886, which must be provided at initial application, recertification, and at any other time that a household member becomes subject to either the ABAWD time limit or other CalFresh work rules relevant to their case. CDSS strongly encourages counties to engage ABAWDs before discontinuing their benefits. As soon as the county becomes aware that an ABAWD has stopped satisfying the work and community engagement requirement at any time during the certification period, the counties must begin monthly engagement with the ABAWD and send these forms and notices. In the next 3 slides, we will cover the details of the CalFresh 886 consolidated notice and oral explanation. The E&T final rule introduced the CalFresh 886, a consolidated written notice along with mandatory oral explanations of work rules. Counties must ensure that all individuals, whether subject to the CalFresh work and community engagement requirement or exempt, receive the CalFresh 886 along with the comprehensive oral explanation during the application process and at recertification. Counties must explain to CalFresh households each applicable work rule, who is subject to each work rule, exemptions from each work rule, who is exempt from each work rule, and the process to request an exemption. Additionally, for each work rule, clients must understand their rights and responsibilities, their requirements to maintain eligibility, any pertinent dates by which an individual must take action to remain in compliance, consequences for noncompliance, the process for and examples of requesting good cause, and finally, contact information to initiate a good cause request. Now, for our final topic for today, let's go over the changes to time limit policy under House of Representatives 1, also known as H.R. 1. As outlined in All County Letter number 2593, California will begin rolling out H.R. 1 changes on June 1st, 2026. Implementation will vary for new applicants, ongoing households, and ESAP households. The next slides explain these differences in detail. The key point is that ABAWD status cannot be determined until the individual is screened under the modified H.R. 1 exemption criteria. Before an H.R. 1 screening has occurred, ABAWDs are not subject to the ABAWD time limit, are not required to meet the ABAWD work and community engagement requirement, do not receive countable months, and are not required to report work hours dropping below 20 hours per week. After an H.R. 1 exemption screening has occurred, individuals found subject to the ABAWD time limit may receive a countable month if they do not meet the work and community engagement requirements, an exemption, or good cause, and must report mid-period if their work hours drop below 20 hours per week. Let's go over how the implementation of H.R. 1 will work for new applicants. For applications received on or after June 1st, 2026, individuals must be screened under the modified H.R. 1 exemption criteria at initial certification. If not exempt from the ABAWD time limit, they must meet the ABAWD work and community engagement requirement and report any drop in work hours below 20 per week. For applications received before June 1st, 2026, individuals are screened at initial certification using the pre-H.R. 1 exemption criteria. At their next recertification, they must be screened under H.R. 1. As a result, individuals who apply before June 1st, 2026 cannot be deemed subject to the ABAWD time limit and work rules until recertification when the H.R. 1 exemption screening occurs. Until H.R. 1 screening at recertification, they are not subject to the ABAWD time limit, are not required to meet the ABAWD work and community engagement requirement, do not accrue countable months, and are not required to report work hours dropping below 20 hours a week. Now, we will cover how the implementation of H.R. 1 will work for ongoing households. Starting June 1st, 2026, ongoing households are required to be screened under the modified H.R. 1 exemption criteria at recertification. Individuals with a recertification due on or after June 1st, 2026, with an effective date of July 1st, 2026 or later, will be screened under the modified H.R. 1 exemption criteria at recertification. If they are not exempt from the ABAWD time limit, they are subject to the ABAWD time limit and must meet the ABAWD work and community engagement requirement, and also must report any drop in work hours below 20 hours per week. For individuals whose recertification is due anytime before June 1st, 2026, HR1 screening will occur at their next recertification. Until HR1 screening occurs at their next recertification, they are not subject to the ABAWD time limit, are not required to meet the ABAWD work and community engagement requirement, do not accrue countable months, and are not required to report work hours dropping below 20 hours a week. Due to the increase in the age range for ABAWDs, households certified under the Elderly Simplified Application Project, also known as ESAP, will be impacted. ESAP households receive a 36-month certification period, which cannot be shortened once assigned. Because for ongoing households, implementation of HR1 occurs at recertification, ESAP households with members ages 60 to 64, whose recertification occurs before June 1st, 2026, cannot be screened under the updated HR1 exemption criteria and cannot be determined subject to the ABAWD time limit until their next recertification on or after June 1st, 2026. As a result, an ESAP household with a recertification due in May of 2026 would be recertified under the pre-HR1 policy and would not be screened under HR1 or possibly subject to the ABAWD time limit until their next recertification in May of 2029. For ESAP households with a recertification due on or after June 1st, 2026, counties must make a good faith effort to contact the household at recertification to screen individuals first for work registration exemptions other than age, and then for ABAWD time limit exemptions before determining whether the individual is subject to the ABAWD time limit. An example of a good faith effort is 3 separate documented attempts to contact the ESAP household. If the county is unable to reach the ESAP household to complete the required HR1 compliance screening at recertification, the county must document all attempts to make contact and then schedule an appointment with the ESAP household. Should the ESAP household not comply with the interview requirement, the recertification must be denied for missed interview. Wrapping up, we have included some resources for your reference. Just as a reminder, you will all be receiving a copy of the recording and the presentation materials after the webinar today. Here are the resources that we have mentioned throughout the slides pertaining to the time limit. And here are some more resources that we have mentioned throughout the slides pertaining to HR1 and the time limit. Before we jump into the Q&A, I just want to take a few minutes to give a quick overview of this webinar series. This presentation is the second part of our CalFresh Work Rules webinar series. The goal of this series is to provide helpful, practical guidance on work registration, able-bodied adults without dependents, also known as ABAWD policy, and ABAWD engagement strategies to support with the implementation of the CalFresh Work Rules. This is a 3-part series. Today is our second session, ABAWD 101. We will be hosting one more webinar in the next few weeks. All of the sessions are held over Zoom, and they do require registration in advance. Please reach out to us at the email on the screen if you are interested in attending and haven't had the chance to register yet. On May 19th, we will have our third and final session. which focuses on ABAWD engagement. That presentation will highlight strategies and best practices for engaging ABAWDs and supporting the implementation of the time limit. Just as a quick note, all 3 sessions are held at the same time, from 10:30 a.m. to 12 p.m. Now I will pass it over to Tanya to kick off our Q&A.
Thank you, Caitlin. We will now be answering questions that were submitted during the webinar. As a reminder, if you have a question, please submit it in the Q&A box below.
All right, thank you so much for submitting all your questions. We answered a lot of questions, which you may see below in the Q&A chat. I will go over a few right now, and we will go ahead and wrap it up right after. All right, first question here. ABAWD Handbook 3.0 states that ABAWD rules may apply to an individual beginning the month after their 18th birthday. However, the handbook also states that any ABAWD time limit exemption will apply through the length of the certification period. So will workers have to complete an exemption screening mid-period for individuals that turn 18 during the certification period to determine if they are now subject to the ABAWD rules, or will these individuals be exempt until their next recertification? And the answer to that is an individual who turns 18 mid-period would be screened for exemptions at their next recertification and would possibly be subject to the ABAWD time limit at that point, if not exempt.
Hey, Tanya, this is Kathy. We're running right up to the very last minute of the webinar, so I think we won't be able to take or do any live Q&A, but do appreciate the ABAWD policy team for providing as much written responses to the questions as possible. I want to lift up that this webinar is recorded and it will be posted and provided to all attendees following the webinar, as well as the PowerPoint materials. I also want to reiterate that the ABAWD Handbook 3.0 ACL was recently released, and let me put some links in the chat for you all to refer to. So in the chat is the general CDSS webpage around ABAWD information, including any updates to waived counties. And then another new ABAWD resources webpage, which includes outreach materials and also where the upcoming webinar registration can be found, as well as the posting of the materials as soon as they are made accessible. And then last but not least, a lot of the information, if not all, was shared based on the ABAWD Handbook 3.0. And let me put that link in the chat. And I'll hand it back to the ABAWD unit to close out for us. Thank you.
All right, thank you so much, Kat, and thank you so much, everyone, for taking time out of your day to listen in today's CalFresh ABAWD Work and Community Engagement webinar. We hope that you found this presentation helpful. You will receive an email with the link to the recording and a copy of today's presentation materials. If you have any additional questions, please send your questions to the CalFresh policy email on this slide. Enjoy the rest of your day, and thank you so much once again.